Thank you, Stephanie. Hello, everyone. Thank you so much for joining us today for our webinar on safe housing for immigrant survivors of domestic violence, legal protections. My name is Carlo Ng. I'm the Director of Legal Initiatives at the National Alliance for Safe Housing. I am very fortunate to be joined today by my colleague at NASH, Jenny Herget, who's our Operations and Communications Manager. She's the person who keeps us all together and makes sure the trains are running. I'm also joined today by my fellow co-presenters, Rosie Hidalgo, who is a Senior Director of Public Policy at Casa de Esperanza, and Grace Huang, who is the Policy Director at the Asian Pacific Institute on Gender-Based Violence. Just a reminder that tomorrow we actually have another webinar, which will be a basics webinar on safe housing for immigrant survivors of domestic violence. During the webinar, we're going to be discussing the realities of immigrant survivors and how those realities can impact our work when advocating for safe housing for them. If you're interested in that webinar and would like to register, Jenny can provide the registration link in the chat box. During these very uncertain times for everyone, and especially immigrant survivors, I'm sure a lot of you have questions for us. For example, we've received many questions about public charge, and how access to housing and health care for immigrants might be impacted during this time. We'll definitely cover those during our presentation today, but if you do have any questions during the webinar, please feel free to type them using the chat box. We'll do our best to answer them throughout the presentation. We'll also have time for a live Q&A at the end of the webinar. Finally, we will be referring to a number of different resources today during the presentation. So we've consolidated all of these resources in a live Google document, which can be accessed with the link at the end of the webinar. So let's go ahead and get started. We'll start by introducing our organization. Like I mentioned, I am with the National Alliance for Safe Housing. We provide technical assistance, training, and support to advocates on housing and homelessness issues impacting domestic violence and sexual assault survivors. If you would like technical assistance and support, you can visit us at www.nashta.org or go ahead and send me an email to my email address, which is at the end of these slides. Now I will turn it over to Grace.
Hi, my name is Grace Huang. I'm the Policy Director at the Asian Pacific Institute on Gender-Based Violence. And for those of you unfamiliar with us, we are an HHS and OVW-funded National Resource Center and technical assistance provider, and we focus on domestic and sexual violence, human trafficking, and other forms of gender-based violence in the Asian and Pacific Islander communities. And we also have a project with Casa de Esperanza and other colleagues, the Alliance for Immigrant Survivors, and we work on policy issues relating to immigrant survivors. And so we work to strengthen culturally relevant advocacy, promote prevention and community engagement, and influencing public policy and systems change. And our main office is located in Oakland, California, and we always have support for others around the country, and we've got offices in Los Angeles and San Diego as well, and our website is up there on the webpage and you can go look at resources there. Thank you.
Hi, this is Rosie Hidalgo, and I'm the Director of Public Policy with Casa de Esperanza, National Latina Network. And Casa de Esperanza was started back in 1982 by a group of Latina advocates to work with, to support survivors, particularly with a primary focus on the Latino community, seeing how at times they were facing additional barriers to access safety and well-being, and to really focus on a strengths-based approach as well in working to address issues of gender-based violence. And Casa Esperanza recognizes that while shelters and DV programs are important and necessary, that ultimately it's about mobilizing our communities, all of our communities across all races, ethnicities, different groups, really mobilizing communities to end domestic violence and build social capital around that. And so in addition to the shelter that we still have in the Twin Cities in Minnesota and a number of programs doing community engagement, work with youth, work with men as allies in the Latino community, we also launched in 2009 the National Latina Network for Healthy Families and Communities. And similar to API GBV, we're a national culturally-specific resource center through the Family Violence Prevention and Services Act and provide a range of support both through national training and technical assistance as well as research, policy advocacy, and education and awareness. So excited to be here today. Thanks so much to NASH for putting this together and hosting this. And we look forward to continuing the collaboration with all of you, anything we can do to support your work on the ground as well. And, the topic for today, as we're looking at the critical issues that all survivors are facing, right? And we know that anyone who's experiencing domestic violence, sexual assault, faces a number of barriers to accessing safety and well-being. And certainly during this time right now with this pandemic, even more so. So again, just really want to lift up each of you who are taking the time to be on this call today to support one another and to continue to see how we can support survivors. And in particular today, looking at immigrant survivors and the added layers of complexity and at times barriers that they encounter in accessing safety and well-being. So we've listed some of these here. I'm sure you all are very familiar with a myriad of additional barriers to accessing services. Language access is definitely a major one, and we'll talk a little bit more about that in this presentation, how we can be proactive to address that. Recognizing that immigrants oftentimes have also faced very difficult experiences in their home country where they may be fleeing gender-based violence that they experience or violence across the lifespan, perhaps mistrust with very valid reasons of systems, of institutions, of courts, and of law enforcement based on experiences in their home country and how that impacts then their ability or willingness to trust institutions and services in this country. The added challenge of fear of removal and family separation, and we see that those challenges have only been exacerbated in the past few years. And how do we make sure then that this is not further sharpening the tools of abusers who rely on that fear, right, who rely on misinformation to make it harder for immigrant survivors to reach out for help. And then there are a lot of other practical barriers that we all see, right, whether it's access to transportation and employment, accessing benefits, understanding what their rights are, the economic barriers, that all survivors deal with economic barriers, but immigrant survivors have added layers of complexity depending on their status, depending on issues of work authorization, and just all the myriad of rules of when someone can or cannot access different services and benefits. And that's even more crucial right now during this time of the pandemic, and we're going to talk somewhat further about that. Certainly housing is a huge part of that, and that's the main focus of our presentation today. What can we do to make sure that there is access to safe housing for immigrant survivors, and then the other supports they need for enhanced safety planning. And then, of course, the immigration-related abuse that we see, that at times perhaps someone's spouse could have petitioned for them to have legal status, but what greater tool of power and control than to keep them perhaps undocumented and too afraid to reach out for services. So Grace later is going to talk about that, how Congress recognized that the immigration system itself could be a tool of abuse and ways in which immigration relief has been a cornerstone from the very first VAWA, Violence Against Women Act in '94, but the challenges that people encounter at times being able to access that immigration relief and how all of you on the front line play such a critical role. If there are additional barriers that you're seeing and want to share that in the chat box, please feel free to do that now. And we know depending on different jurisdictions, people are encountering other challenges. But at the same time that we're lifting up barriers, really want to emphasize how do we also do this work from a strengths-based approach. And that's something that through the years, Casa Esperanza, we've really come to recognize the importance of that. That just when an immigrant survivor reaches out for help, right, sometimes I know as advocates we might be like, oh my gosh, this is going to be challenging, it's complex. But at the same time, how do we just pause and say like, wow, this individual has a vision for themselves, for their children, of safety, of well-being, of overcoming tremendous challenges, of resiliency, of perseverance. And the honor it is to walk with that person then on their journey towards finding safety and well-being. And so how do we also lift that up and make sure we're asking that survivor, sort of, what are your goals? What are your priorities, right? We can certainly offer information, offer different pathways, but honor that for different people it may look different, the ways in which they're trying to seek support and safety. So that is something that Teresa tomorrow, who is the leads our shelter at Casa Esperanza, is going to talk a lot more about that. But just wanted to also lay a little bit of that context for today's discussion. And then the other thing that we look at, too, is just as we're working with immigrant survivors, how do we recognize that a lot of us, of course, are very aware of the abuser-generated risk, and that's an important part of safety planning. But at the same time, what does it mean to really look more holistically and recognize that an individual is facing not only abuser-generated risks, but there are life-generated risks, right? And then certainly there are system-generated risks. And so the enhanced safety planning really needs to look at all of that and really engage in that conversation with the survivor to make sure that we're holistically doing both that assessment and safety planning, and then also looking for resources and opportunities across different places. But I think right now is a critical moment. Like, let me give an example, right? The life-generated risk that everyone's dealing with is the fact that there's this pandemic out there, and the tremendous now risk to people's health and well-being and economic well-being, uncertainty, the trauma that brings. And now we're layering on that, right, that we have individuals that we know who are facing significant abuser-generated risks, and in many cases having a shelter in place with that individual. And so that's added layers of complexity. And now we add the third layer of systems-generated risk. And in the midst of this, are systems really being responsive? Are the economic relief being put out there really accessible to immigrant survivors? Are the courts, as they're moving to remote hearings, how are we addressing the digital divide, the language access issues? Is information reaching communities in different languages? Do they know that we are available, all of our programs, to help them? Are we being proactive and helping them navigate now even greater complexities in systems? So again, it's looking at this holistic approach as we do that kind of assessment and safety planning. And so now, in light of that, we'll hand it over to Grace to talk about some of the critical protections for immigrant survivors.
Hi, everybody, and thank you, Rosie. So as Rosie mentioned, some of the risks that are posed to survivors are system-generated, including those in the immigration system. And we know from our work with immigrant survivors that the abusers, leverage the immigration system as a tool of power and control. And so based, on the work of many advocates, some of this on this presentation, some of whom are on this chat or on the webinar today, we have worked on legislation to make it so our immigration laws are not as easy to be used as leverage against victims. And so in the Violence Against Women Act and in the Trafficking Victims Protection Act, there are immigration-related protections specifically for survivors. And, Congress has worked on those protections in a bipartisan manner, worked to create these protections since 1994. And we've worked over the years to strengthen those protections, trying to fill in gaps when they're identified. And so we'll be talking about some of the specific legal protections that are in the Immigration Code in the next few slides. And so, there was lots of testimony and evidence provided to Congress when this legislation was initially passed and in the subsequent iterations about how abusers, often threaten victims with deportation, how that they'll turn people over to the immigration system. And so we've worked really hard to make sure that the immigration system, we've tried to minimize some of those, the ability of abusers to do that. And so we continue to try to strengthen those. I mean, as we know in the last, all throughout time and more so in the last few years, is that the overall immigration system continues to be an area of fear, and we, have heard, particularly in the last few years, about the increase in concern that folks have around jeopardizing their ability to stay in the United States. And so I'm going to talk about some of the particular legal remedies that exist in the Immigration Code for survivors. But before I get to those, we also, in talking about, the immigration system, we also want to talk about how just the immigration law fits in with a whole range of different protections, legal protections that are available to immigrant survivors. And so when we talk with advocates, we also remind them, yes, there are ways that people can get immigration status, but there are also other protections in our laws that we want to emphasize and make sure that survivors know are available for them. And so those include the Constitution and, the right to due process and the right against self-incrimination. And in doing safety planning with survivors, one of those pieces, relates to the right for individuals to have court hearings and or the right to not disclose where they and to not, to immigration officers if people are detained. So those rights are embedded in the Constitution. There's also federal rights law, or federal law, including civil rights laws, laws that provide access to services necessary for life or safety. And we'll talk a little bit about, where that plays out as we continue our webinar today. There's the Violence Against Women Act, not only the immigration protections, but also the other protections in VAWA, such as those related to funding for services for all of our victim services programs around the country, as well as the Family Violence Services Protection Act and Victims of Crime Act. Those include services that are available for immigrant victims. And then there's the Immigration Code, which I'll talk more specifically about, as well as wage protection laws. There's international law. The United States is a party to many international treaties as they relate to refugees fleeing persecution, International Treaty on the Convention Against Torture for those fleeing to the United States. And, right now we are seeing a lot of challenges as to whether or not all of our obligations are being met under those international laws, but there are advocates out there trying to make sure that victims are able to access the protections afforded under those international laws. And then we have our state laws, and this is where many of you do your work around providing access to safety for immigrant survivors. There are protections, confidentiality protections that protect victims from their information being disclosed to others, such as law enforcement or immigration officers. There are housing laws, state and local services provided. Some states have certain U-Visa certification laws relating to when law enforcement is required or should be certifying for people's immigration status, and I'll talk about that in a minute. But when we are working with immigrant survivors, it's helpful for us to be talking with them about the range of services, of laws, and things that protect them that often don't have any restrictions related to immigration status at all. And so trying to remind folks that they have all of these protections available for them and helping them safety plan is really important in helping people recognize that that we have a whole range of protections available. So I'm going to go on to specific immigration law protections for people that exist. And so this particular graphic was put together by the Department of Homeland Security in terms of trying to show the range of remedies that might be available to immigrant victims if they are applying or needing protection from deportation, et cetera. And so some of these include the VAWA self-petition for family members of U.S. citizens and permanent residents, and I'll talk about the requirements in a minute. There's the U visa for victims of crime who've collaborated with law enforcement or prosecution. For trafficking victims, there's the T visa for, and continued presence. Those two relate specifically to survivors who've experienced human trafficking. There is the special immigrant juvenile status, which is available for minors who have been abused or neglected and have been found by a state court judge to be allowed, if I guess the law states that if there's a finding by a state court judge that it would be in the child's best interest to be able to stay, well, to be dependent on a state court. There's that remedy, and then there's asylum, which is a protection in our immigration code as well as under international law that protects people who are fleeing persecution, and over the years has included survivors of domestic violence and sexual assault, and so that remedy still exists, though it's become much more complicated in the last few years. So what I'm going to do is talk in particular about some of the remedies that may be more common, and those are the VAWA self-petition, the U visa, and the T visa. So the VAWA self-petition, and people often forget about this one because, for some reason, a lot of folks in our field want to talk about the U visa, but the VAWA self-petition has existed since 1994 and has been expanded over the last several years. But the law provides, and so the petition was based on existing family-based immigration protections because generally, and about 2/3 of our immigration to the U.S. Is based on family relationships where a U.S. citizen or somebody here who has a green card or is here with lawful permanent residence, they can apply to sponsor a family member to immigrate to the United States. And so the VAWA self-petition was created in 1994 to eliminate that power and control dynamic so that victims who have experienced battery or suffered extreme cruelty by their spouse or parent or their U.S. citizen son or daughter, if they abuse them and they were otherwise eligible through the family visa system, they could apply on their own under the Violence Against Women Act, and they could file a self-petition under VAWA. So generally, the requirements to be able to access that self-petition include, having lived with the abuser. They, have to show good moral character, and for those applications based on marriage to a U.S. citizen or a permanent resident, the individual has to show that they entered that marriage in good faith. So they didn't, meaning under immigration law, that they didn't marry just for the purposes of getting immigration status. And so, that remedy has existed since 1994. In 2000, we also, under the Trafficking Victims Protection Act, created the U visa and the T visa. And the U visa is there for victims of qualifying crimes, and there's a long list of crimes, including felony assault, including domestic violence, including sexual assault, including a whole range of different crimes. Stalking is another one. But the list is generally violent crimes. And the person has to also establish that they've suffered substantial physical or mental abuse as a result of the victimization, that they had information about the crime, they were helpful or are being helpful or will be helpful in the investigation or prosecution of the crime, and the crime occurred in the United States or violated U.S. law, and then if they also have to show that they're admissible, meaning, there's a long list of grounds of inadmissibility for health reasons, for crime reasons, etc. But they generally need to show that they're admissible or they're eligible for some kind of waiver in the national or public interest. And so the interesting thing about the U-Visa is the element where they have to show that they've been helpful in the investigation or prosecution of a crime. This involves having to get a certification signed by law enforcement or a prosecutor or a judge. And so, that is the work of a lot of local advocates in educating local law enforcement officers and prosecutors in courts to understand the role of law enforcement in certifying that folks have been helpful. There's also the trafficking victim visa, which is for those who were victims of a severe form of trafficking, and they are that individual present in the United States on the account of the trafficking, and they have complied with a reasonable request for help in the investigation or prosecution of trafficking, and they would suffer extreme hardship if they had to return to their home country. And so these are like really quick overviews of these particular forms of immigration relief, and these are a few of those protections available for victims that are specific to victims. And then we also have a whole range of other types of immigration status, like employment and like I mentioned before, the family-based system, as well as the diversity visa, asylum, etc. So when immigration lawyers sit down with clients to figure out what might be the best path in terms of accessing one of these forms or multiple forms of immigration protection, people may be trying to decide whether they apply for one thing or another thing, and so depending on their eligibility, of course, and if they can meet the statutory requirements, but there are different benefits available to different folks based on their immigration status. For example, the VAWA self-petition involves, once the person applies, they can include their children as part of their application once it's approved. Generally, folks can get access to work authorization. And VAWA self-petitioners under our federal public benefits law that we'll talk about more are generally eligible for a greater range of federal public benefits after they've had that status for after 5 years. There's the U visa. Folks can be included as beneficiaries in that U visa application if they're a victim of crime. And so after application's been approved, which is these days is taking a really long time, unfortunately, but after the application is actually approved, there's a 2-year work permit based on deferred action. And, while they're waiting for a U visa to become available. Now, the challenge right now is because of the 10,000 visa cap that there is every year, there's a very long wait list to be able to get the U visa. And so it's taking a long time for people to get onto the wait list to start with, and then they have to wait for the U visa itself. So once the U visa is actually issued, the U visa is valid for 4 years, and then they can apply to get a green card or become a lawful permanent resident after 3 years with that U visa. And then there's the trafficking visa, the T visa, that provides for a 4-year visa, and after a certain amount of time, they can apply to become a permanent resident as well. It can include certain family members that is broader than the list that is there for U visas. And they are fit into a different category in terms of access to public benefits, and they're treated essentially like refugees, and so have access to a wider range of public benefits, and don't have to wait for 5 years with that status before they can access them. And so some folks may be eligible for all 3 of these at one time. Some folks might be eligible for both a T visa or a U visa. And so, what the point being is that people really should be getting individualized advice from an experienced immigration lawyer to figure out how, which remedy might be most appropriate for them. So I did see in the chat one question about how yesterday's announcement about blocking immigrants from entering the country affect those fleeing violence. So I want to just flag for you right now, we've been scrambling this morning to do some analysis about that executive order that came out yesterday. I know that ASISTA has, we were working on a blog post this morning, and so that analysis has, I think it's already on, if not already on their website today, it will be by tomorrow morning. But essentially it applies for people who are outside the United States and are seeking to enter the United States as an immigrant. And that means people who are seeking to become permanent residents of the United States. And so for the most part, it applies to people, for victims of domestic violence and sexual assault. There are broad exemptions for those who are married or, immigrating to the United States based on a relationship with, spouse or children of U.S. citizens who have an approved VAWA self-petition, for example. They would be exempt from the executive order, but spouses and children of permanent residents are subject to the bar. So, it's really hard to do this quickly, but I would commend the blog post on ASISTA's website for the analysis. For right now, the executive order does not apply to those with U's and T visas, but we know in the executive order they will be reviewing non-immigrant visa categories, which U and T visas are, and so as of this moment, they're not subject to that bar, but we'll be examining that, I'm sure, in the next couple months for new announcements relating to those visas. I'm going to move on and hand this back to Rosie, I believe, or no, to Carlo about eligibility for housing based on immigration status.
Thank you so much, Grace. So here we have our first polling question, and we want to hear from you. So please go ahead and complete the poll. Are survivors eligible for shelter and transitional housing services regardless of their immigration status? Yes, no, or no vote? We'll give folks a couple of seconds to do that. Okay, I think we can go ahead and close the poll. So it looks like almost all of you think yes. So excellent. That is the correct answer. So the answer is generally yes. And how do we know that? Well, we know that because a federal law tells us that. This federal law is called, it's a mouthful, the Personal Responsibility and Work Opportunity Reconciliation Act of 1996. We call it PRORA for short. So it's a federal welfare law that created immigration restrictions for individuals accessing certain federal public benefits. The same law also established an important emergency services exception to these restrictions. And so what VAWA basically tells us is that if the federal benefit is a service that is, one, necessary for protection of life and safety, and is two, in kind or free, and is three, not means tested, which basically means it doesn't take into account someone's income and savings, then this benefit must be provided regardless of someone's immigration status. And then in 2016, there were 3 federal agencies that issued a joint letter. So the U.S. Department of Housing and Urban Development, HUD, U.S. Department of Justice, DOJ, and U.S. Department of Health and Human Services, HHS, issued a joint letter confirming that programs receiving federal funds cannot prohibit individuals from accessing emergency services necessary for life or safety because of their immigration status. On this slide, you'll see that we have provided some of the examples that the joint letter lists in the letter as examples of types of services that cannot have any kind of immigration status requirements. So we see here there's short-term shelter or transitional housing assistance up to 2 years, crisis counseling and intervention programs, child and adult protection services, soup kitchens and community food banks, medical and public health services necessary for life or safety. And just to note there that during this pandemic, it's really important to know that immigrants do have rights to access emergency medical services, and Rosie will be providing really important information about that a bit later. Continuing with the list, assistance to help individuals during adverse weather conditions is also a service that cannot have immigration requirements, and any other services necessary to protect life or safety that meet this 3-part test. The same joint letter reminded federally funded programs that there are federal non-discrimination laws like the Violence Against Women Act, the Victims of Crime Act, and the Family Violence Prevention and Services Act that all require that the programs provide benefits regardless of someone's race, citizenship, nationality, or immigration status. Over the next few slides, I'm going to provide for you a list of the federal housing programs that have immigration status restrictions. Now, these immigration status restrictions come from a federal housing law called Section 214 of the Housing and Community Development Act of 1980. Throughout this presentation, we'll refer to the set of immigration restrictions as Section 214. So Section 214 tells us that in terms of the HUD program, so these are programs that are administered by the U.S. Department of Housing and Urban Development, this list of programs have immigration status restrictions. So they are public housing, housing choice voucher program, the Section 8 project-based housing program, Section 236 housing, the 235 home ownership program, the housing development grants, and the Section 23 lease housing assistance program. I think for purposes for advocates on the phone today, I think most folks will be coming into contact with the first 3 programs. They are by far the largest programs on this list. This list actually includes programs that are no longer active programs, but because there are still units on the market that have received these subsidies, we continue to talk about them. But practically speaking, advocates and survivors will most likely be coming into contact with the public housing program, the housing choice voucher program, and the Section 8 project-based housing program. Continuing with our list of programs that have immigration status restrictions that are required by Section 214, we're looking at rural programs. So for our advocates and survivors in rural areas and work with the affordable housing programs that are operated by USDA's Office of Rural Development, these programs also have immigration status restrictions. So they include the Section 514 and 516 farm labor housing programs. These are housing programs that are provided for farm labor workers. The Section 502 single family home ownership loan program. The 504 single family housing repair loans and grants program. And the Rural Development Voucher Program. The Rural Development also has a voucher program that is similar to the voucher program that HUD provides, although it operates differently. But the RD program The RD office also has a voucher program. This slide is a slide that is not comprehensive, but we wanted to provide you information with a list of programs that actually do not have any federally required immigration status requirements. So it's actually quite a long list. I'll go ahead and read it for you. So the Federal Low-Income Housing Tax Credit Program does not have immigration status requirements. The HUD program, Section 202 housing for the elderly, as well as 811 housing for the folks with disabilities. HUD Section 221D3 program, which is assistance that is provided to multifamily housing providers. Indian housing, community development block grant programs, housing opportunities for people with AIDS and HIV, which is also a HUD program. The McKinney-Vento programs, which I believe a lot of advocates on the phone are operating with funds or have funds from their local continuums of care. So COC and Emergency Solutions Grant programs also generally do not have immigration status requirements, although there's a caveat, which is why there's that asterisk next to some of these programs, which I'll explain in a little bit. Importantly, a common question that I've received over the years is rapid rehousing, because there are so many funds being used towards rapid rehousing, whether or not there are immigration status requirements. The answer is no. There's actually a fact sheet that came out of HUD SNAP's office in 2016 that confirms this. There's a link to it right there, but at the end in our Google document that has a list of resources, you can also find the link there as well. And then there's the rental rehab program, HOPE 2, Section 515 rural rental, the Rural Housing Preservation Grant Program, and the 538 multifamily loan guarantees. Now the asterisks. I put the asterisks next to some of these programs because it gets a little bit confusing when there are layers of financing that are being used in an affordable housing complex. And financing layers are very common. They're very common because oftentimes a use of a single stream of funding from the federal government is not actually adequate to make units completely affordable for low-income and very low-income families. And so because of this, additional streams of funding must be used to close that gap so that low-income families can truly access these units. And so some of these forms of funding oftentimes come with immigration status requirements. So a really good example is actually in the Section 202 and 811 context. So housing for the elderly and folks with disabilities. So these are two programs that are operated by HUD. But unfortunately, the use of just that funding, 202 and 811, is oftentimes not enough to make a unit truly affordable. And so the project-based Section 8 program is often used as an additional layer to really close that gap for poor families so that folks can access those units. But project-based Section 8, like we said in the previous slide, has these Section 214 immigration requirements. So that means that certain folks who are immigrants will not be able to access these programs. For CDBG, CDBG generally does not have any requirements. The exception are special category CDBG programs. So for example, the CDBG disaster recovery funds oftentimes come with immigration status requirements. So just a note about that. The asterisk next to McKinney-Vento, so generally speaking, COC ESG, no immigration status requirements, unless there is some kind of Section 214 program that is triggering immigration status requirements. So a really good example of this, although this is a fairly small program, is when Section 8 is used. So the Section 8 moderate rehabilitation funding source has been used to fund, for example, the single room occupancy program, so Section 8 moderate rehab SRO program. Because that money comes from Section 8 and Section 8 has immigration status requirements, that program has immigration status requirements. So who is eligible for the Section 214 housing? This is the list. It includes U.S. citizens, U.S. nationals, folks with green cards, lawful permanent residents, VAWA self-petitioners. So VAWA self-petitioners, that category is not explicitly listed in the statute, the Section 214 statute. However, HUD in 26 issued a legal memo confirming that VAWA self-petitioners are included as being part of the list of folks who are eligible for Section 214 housing. Refugees and asylees are also eligible. Qualified victims of trafficking, including T visa holders who are treated as refugees, parolees, and persons granted withholding of removal and deportation. If you'd like more information about the categories of folks who are eligible and folks who are not eligible for HUD programs, you can go ahead and look at this resource from our partners at the National Immigrant Women's Advocacy Project. And also feel free to ask us any questions in the chat box. What about U visa holders? It's a really good question. We get the question a lot. I mentioned previously, VAWA self-petitioners are on the Section 214 eligibility list. What about U visa holders? U visa holders are not among the categories of immigrants eligible for 214 housing, unfortunately. So for advocates who are working with U visa holders and want to fit them into any category or want to get them access to any of these 214 programs, they're going to have to fit them into any category listed in 214, such as victims of trafficking, or they may qualify for other types of non-federal housing programs. So like I mentioned before, there is a list of programs, of federal housing programs, for which there are no immigration status requirements. So definitely look at those for U visa holders and other folks who might not be eligible for immigration reasons. Really important too is that there are state and local programs, many state and local programs that do not have any immigration status requirements for their housing assistance programs. In California, there are quite a few, in Massachusetts and other states. So look into those state and local programs as well in terms of a resource for survivors that might not be eligible for Section 214 housing. Mixed status families. So mixed status families are folks who are families that are comprised of folks with different immigration statuses, and at least one member of the household does not have an eligible immigration status for purposes of applying for Section 214 housing. But what HUD has told us about Section 214 and its requirements is that if at least one member of the household has eligible immigration status, then the family can receive prorated assistance, or the assistance gets decreased to reflect the fact that there are folks in the household that do not qualify for the assistance. So this person, this one eligible member, can be anybody. It can be a minor child that is eligible, who isn't the eligible household member. So we actually had a situation before where the household was actually just comprised of the mom, who was an adult, and an infant child. And the infant child was a U.S. citizen, and the mom did not qualify for the housing assistance. And they, as a family, received a housing choice voucher, which is covered by the Section 214 and therefore has immigration status requirements. That household was able to be eligible and receive a housing choice voucher because of the infant child. And that was totally legal and fine. And the non-eligible family member certifies that they do not wish to claim eligibility for the housing program, and they can still live in the assisted unit with other family members who do qualify for the assistance. Importantly, the family member who doesn't claim eligibility, they do not have to provide a Social Security number or information about their immigration status. That's really important because there's been a lot of confusion on the ground, including, unfortunately, by housing providers like public housing authorities who insist on asking for certain kinds of documentation for people who are not claiming eligibility for the housing assistance, like asking for Social Security numbers, different kinds of legal documents, and they are not required to do that. So as advocates, part of our job is to actually educate the housing providers of what they are supposed to do and not supposed to do under the law. A note here, so as some of you may have heard, there has been a rule that has been proposed by HUD that is pending finalization, where the agency, really the administration, is seeking to eliminate access for Section 214 housing for all mixed status families. They're basically trying to bar mixed status families from being able to live in Section 214 housing programs. It is a problematic rule because effectively what that means is that the 25,000 families that are mixed status families that are currently being assisted by the HUD programs and other Section 214 programs will lose their assistance in those households. There are approximately 55,000 children, many of whom are U.S. citizens, that are living in those households that could potentially face homelessness because they will be kicked out by this rule. But in any case, there is a proposed rule by HUD, and then USDA Rural Development is also proposing a similar rule that is at OIRA right now. And now I will hand it over to Rosie.
Great. Thank you, Carlo. And just an additional comment I want to add about the mixed status rule that's pending at HUD. As you all are aware, many times when these proposed rules are put out, there's an opportunity to offer public comments. And I just want to raise what a critical role that is for all of you out there who are working with immigrant survivors when opportunities come up, whether it's a HUD rule or other rules. And just to reiterate that as nonprofit organizations, that is well within what a 501c3 nonprofit can do, because essentially the federal agency is putting out there for public comment saying, we're thinking of doing this, let us know what are the pros and cons as you see it on the ground. And so each of you play a really critical role for doing the kind of advocacy. I know we're used to doing individual advocacy, but this kind of systems advocacy is so critical. And there were so many comments that were submitted to HUD helping raise the concerns of the negative potential impact. And so that's just really important. And for all of you who were able to submit comments, just want to thank you and encourage us to continue to find ways to do that kind of system advocacy. And so the rule has not been finalized, and that's helpful too, because they need to go through all those public comments when they receive them. So just want to reiterate that in the meantime, if you're aware of mixed status families in eligible public housing or considering trying to access that housing, they can still do so because the proposed rule has not been finalized, is not in effect. So I just do want to reiterate that. And you know, the topic of this webinar today is primarily housing. So public benefits could be in another entire 2 hour or 2 days workshop. But did want to nonetheless just highlight that there are some resources out there, because I know that your enhanced safety planning and working with immigrant survivors when you're working on accessing housing are also looking at what other types of economic resources are available to support immigrant survivors. And I do want to pause here and just sort of remind all of us, right, how difficult it is and how cautious we need to be and respectful when having these conversations with an immigrant survivor, because it's difficult to broach the subject of someone's immigration status, right? And to make sure there's that trust, that confidence, and that they understand the confidentiality that this information will be protected by you when you're asking. And so, you know, just pausing a moment, first of all, to acknowledge that there's such a big range of immigration status. I think, you know, all of us, of course, are very concerned about the detrimental impact on undocumented individuals in terms of being able to access different housing or benefits. But we certainly don't want to make those assumptions. We want to recognize that a significant, about half of all foreign-born individuals are actually naturalized U.S. citizens, and so have full access to all the different benefits. And so we don't want to make assumptions. And we also need to recognize there's a range of legal permanent residency, and then how long someone has or hasn't had that could impact their access to housing or other benefits, as well as a range of other different statuses. So it can be complex, and that's why it is really important for our organizations also to have partners in the community who understand immigration advocacy or immigration law, or even other organizations, you know, legal services providers that have attorneys who sort of specialize in working with immigrant survivors, but certainly never, you know, make assumptions about someone's status. And I think, as Carla really highlighted, to be aware that there's often mixed status in families, and so not make assumptions in that regard as well, because even if the survivor herself or himself is not eligible for a benefit, if the child's a U.S. citizen, they might be able to access other benefits. So again, it's how do we have that conversation, and in doing so, maybe say to them, you know, if you have any concerns potentially around immigration status, as we talk about different possible options for you, I want you to know that the information you share with me is confidential. And like Grace said, that is such a cornerstone, and we're so grateful for that, that in VAWA, in also FIPSA and in VOCA, all this federal legislation makes it very clear when working with immigrants about protecting confidentiality. And so that's something that you can tell the survivor that, because many times the abuser, again, these things sharpen the tools of abusers, because many times even abusers will say, if you reach out for help, if they find out you're undocumented, they're going to, throw you out of the shelter, they're going to call ICE. And so it's oftentimes with fear and trepidation that someone might approach your program. And so how to put someone at ease and let them know that you're there to serve all survivors and what they share with you is confidential as you help them navigate these complex systems. So again, in looking at benefits, there are the federal public benefits that have a range of different eligibility criteria. And then there's also always looking at your own state and locality, because some states and localities have been able to be more generous in making sure that there's access to economic resources regardless of immigration status. So this map is put together by NIWAP, the National Immigrant Women's Advocacy Project out of American University School of Law, and they are a TA provider under the Office on Violence Against Women. And just commend it to you all. You can look at your state and see a range of different benefits and to see what might be available there for immigrant survivors in your community. And also at this time, of course, as we're hearing about different legislation coming out in response to the COVID-19 pandemic, there's a lot of questions about what can immigrant survivors potentially access. So, for example, we're hearing about the rebate stimulus checks, right, which are $1,200 per individual, $2,400 if filed jointly, and potentially another $500 for each child. And that does have a requirement that individuals have to have a Social Security number, and they're using the taxes that they have filed either in 2018 or 2019 to determine that eligibility. So again, we can't assume that immigrant survivors are not eligible. A substantial number of them, do have Social Security numbers, and if so, making sure, don't assume that, make sure how, especially if they're now in shelter, especially if potentially it was filed under the abuser's name, how do we help them be able to access a potential rebate check? A great concern that folks have raised is that there are actually a lot of immigrants who work and pay taxes. Over 4 million file federal taxes every year using an ITIN, Individualized Tax Identification Number, and about $13 billion in taxes are paid through that. So advocates are raising that point, to remind Congress that rebate and stimulus checks should go, if it's going to taxpayers, should recognize that there are a lot of immigrant workers who in fact are taxpayers using an ITIN. And while that was not included in the COVID-3 package, it is something that there's been a lot written about that and a lot of education of policymakers that is going on to see if that can be expanded to include those who do in fact pay taxes using an ITIN number. One of the things also in COVID is the right to access paid sick leave. And the federal legislation did say that that is something that should be available regardless of immigration status. So that's an important thing to be aware of. So there are a number of different issues to take into consideration as we're seeing these new pieces of legislation coming out. And in the resource sheet that Jenny referred to at the beginning, you'll see there's some links to some excellent resources that were just recently put together by the National Immigrant Law Center and by Protecting Immigrant Families. They have a good chart and additional information that I would encourage you to take a look at as you're working with immigrant survivors to see what may be available to them. Now, in the midst of all this, there are also significant concerns about public charge, and Grace is going to talk more about that. But generally speaking, we want you to just be aware, even, for example, when it comes to looking at public benefits, again, that if a child is eligible for a benefit because they're a U.S. citizen, then, we encourage you to explore how to access all those different economic resources, and that's separate from the public charge that might be considered when an adult is looking to adjust their status. But Grace will talk about that more. But we also want to talk about the public charge concerns with regard to access to health care for immigrants. And just generally speaking, this is such a critical issue right now in the midst of this pandemic. And we just have great concern, like how do we get the word out to all communities, and particularly to immigrant communities, particularly those who might have language access barriers, to encourage people to seek health care. And this is, of course, critical right now in shelters, right, and in other housing programs. We want to make sure that people are being tested, that they're able to access the health care to stay safe. And so this is important information, I think, that all of you can help get out. So one thing that we want to emphasize is there is a category within Medicaid. Medicaid itself, generally speaking, has requirements regarding immigration status, but there are some exceptions. And one of those exceptions is emergency Medicaid. And so it's important to know that emergency Medicaid is available to individuals who are otherwise eligible for Medicaid, but for their immigration status. So that would include those with temporary protected status, those who are DACA recipients, Deferred Action for Childhood Arrival, those who are lawful permanent residents but have been here less than 5 years, and individuals who are undocumented. Whereas they would not be eligible for Medicaid generally, they would be, if their income still, is within the guidelines, would be eligible for emergency Medicaid. And so that's especially important right now during this time of COVID-19 to encourage people to access health care. Also, immigrants and their families can continue to seek services at community health centers, regardless of their immigration status, either at a reduced fee or at no cost, depending on their income. So you'll see there's a link here to where to find the nearest community health centers. And the legislation that was recently passed by Congress did allocate an additional $1 billion to also help pay for COVID-19 testing for uninsured individuals through the National Disaster Medical System. So at a lot of hospitals and other places, if they test someone who doesn't have insurance, they potentially can also get, through the National Disaster Medical System, the reimbursement for COVID-19 testing. Advocates are raising the fact that it would be best to also consider testing itself something eligible for emergency Medicaid. Some states have already done that, like New York City. Others are, taking that broader interpretation that emergency Medicaid covers both testing and treatment. But there is an effort underway for policymakers to really clarify that and make that a national policy. But in the interim, there are other ways to still get the COVID-19 testing covered for the uninsured. And again, we should just encourage everyone to, who may need testing, may have been exposed, to seek that out. And there are some concerns, again, regarding public charge. And USCIS, the U.S. Citizenship and Immigration Services, did put an alert clarifying that to access testing, treatment, preventive care related to COVID-19 will not be considered a negative factor in any subsequent public charge determination at the point where someone is adjusting to become a lawful permanent resident. So if you hear anyone say, no, I'm concerned that then later this might impact my immigration status, you can tell them that, this alert has been put out. Similarly, USCIS did put out an alert just reminding everyone that hospitals are considered sensitive locations where ICE enforcement should not be occurring in those locations. And Grace will later talk about other sensitive locations with regards to shelters and otherwise. But again, during this critical time, we really want to make sure that we can support everyone, including immigrants, in accessing health care for their safety and well-being and that of their families and communities. So I will now hand it over to Grace to talk a little bit more about public charge issues more broadly.
Thank you, Rosie. So, as I've been working with advocates around, access to benefits over the last several months, in particular, and in the last month or so, there's the concern about this thing that people have been hearing in the news about public charge is really at the forefront. And so I'm going to spend some time talking about the public charge rule that just went into effect in February. But, we've been hearing about this rule for almost 2 years now because it was mentioned when this in 2017 as one of the things that the administration was going to be working on in addressing immigration policy. And so, we've seen many of us have worked on reading drafts and providing comments, and ultimately the rule has, the new public charge rule has gone into effect. It went into effect in late February because initially the rule was published last fall in 2019. There were several lawsuits filed challenging it because of the hundreds of thousands of comments that were filed in response to the proposed rule. The litigation is still pending. Initially, at the beginning, there were some temporary injunctions in place, but the Supreme Court in January reversed those temporary stays of the rule going into effect, and so the rule did go into effect at the end of February. However, the litigation, just so that folks know what's happening with all that, the litigation is still going on. There's discovery happening, and so while it's taken effect, we don't know what the outcome of all of the litigation and the lawsuits around the country will be. So, this, of course, is potentially subject to change based on what happens with that litigation. In any event, I am going to go over what the rule does say that took effect in February so that people can get some clarity around this. So what the rule did do was it created in the regulation a new definition of public charge. And it put in a new balancing test in trying to figure out if somebody's likely to become a public charge, considering the whole totality of the circumstances, and it listed more public benefits that can be considered by immigration officials in determining if somebody's likely to become a public charge. So in the past, the public charge rule, for decades, was essentially, somebody might be considered inadmissible because they were, or not eligible to get their green card because, or not eligible to be admitted into the United States because they were likely to become a public charge, meaning they were going to be, primarily dependent on public benefits. And so that rule was changed in the regulation to become public charge now means a person who receives one or more public benefits for more than 12 months in the aggregate within any 36-month period. And such that, for example, if you receive two benefits in 1 month, it counts as 2 months. And it doesn't matter what the financial amount is. For example, you could receive cash assistance and $5 in food, federal food assistance, and that would be counted as receiving 2 months worth of benefits. And so if you receive cash benefits, housing assistance, that is under the rule, and food assistance, that would count as 3 months. And so if you receive more than 12 months in the aggregate of within any 36-month period, you would be that person would be considered a public charge. So while there is that definition, that's one the Immigration Service, or DHS, is supposed to consider whether you're likely to become that person that is going to receive more than 12 months of benefits in the aggregate within a 36-month period. So it's a forward-looking test. It's not, looking at whether you actually did receive, what your past benefit use is per se, because they have to look at the totality of the circumstances in deciding whether in the future, if you're admitted as an immigrant, that you're likely to receive more than 12 months of benefits in a 3-year period of time for a particular purpose. And so, when somebody comes in as a student or as somebody coming into work, for example, but technically the rule does apply to them. In addition, so somebody is adjusting their status or trying to get their green card to be allowed to live indefinitely in the United States, and or applies when a permanent resident leaves the United States for more than 6 months at a time and re-enters. So, they are seeking admission again to the United States. It does not apply to, certain immigrants, and so there are large categories of immigrants who are exempt, including refugees, asylees, victims of trafficking, human trafficking, and domestic violence. So, the categories that I had listed earlier as, specific immigration service protections available for immigrants, that include the Violence Against Women Act, folks getting U visas, folks getting T visas, special immigrant juveniles. Those categories of individuals are not subject to the public charge rule. And people, are often concerned about, even if they have this status, whether or not getting certain benefits will impact them. And, these protections or these exemptions are in the statute. They are in the immigration code. And so the Immigration Service and DHS cannot change the rules about these groups of people, and the only way that it would ever change is if the law changes, or the statute, legislation is passed to change that, which we don't know of any of that pending. So it's also not a consideration for people that already have permanent residence, and that when they're applying for U.S. citizenship. So, we are also hearing about a lot of people who already have their green cards, they're already refugees, they've been here for years, and, they keep, they hear about this vague public charge rule in the news, but they are not subject to the public charge rule. And so, it's incumbent on all of us to make sure that people have access to good information about that, because we know, and we've heard from healthcare providers, from teachers, from domestic violence advocates, and folks that, we have a lot of people in the immigrant community who are afraid of accessing various public services and benefits because they've heard about this rule, and, it's intended to be confusing. It's the media has been talking about it for a long time, and so we want to make sure that people, there are a lot of people to whom the rule doesn't apply at all, and they're still, declining important benefits. So what the public charge rule does do is, part of the confusion is because public benefits are, are a big mix of, federal benefits, local benefits, state benefits, et cetera. And a lot of our various programs, including housing programs, are locally, our individual programs are funded from a whole range of different sources. And so it's really, really challenging to figure out whether or not, if somebody accesses certain benefits, whether the public charge rule, whether they'll be impacted by the public charge rule in the future. And so one of the things the rule does do is it expands the list of benefits that the Immigration Service can consider when determining if somebody should be denied immigration status. And so they'll look to see if somebody's accessed these benefits in the past. The reality is most non-citizens are not eligible for a lot of federal public benefits anyway, so for the most part, folks won't have access to a lot of these benefits. But there are some exceptions, of course, and there are state benefits and local benefits that people may be able to access that don't have the same immigration restrictions. And so, just want to make sure that people are clear about which benefits they are that immigration can consider in determining as a negative factor when they're have one for general assistance, for SSI, or long-term institutional care at government expense. Those have always been things that the Immigration Service could consider receipt of for determining if somebody was likely to become a public charge. And so the cash assistance for income maintenance is, one that's generally income-based. It's like you're eligible if, you're low income or no income. And it's not generally one-time assistance or short-term assistance. And then in the new rule, there are also, they added other federal public benefits, such as supplemental nutrition, the SNAP program or food stamps, and these are the federal SNAP or food stamps, not state or local programs. There's Medicaid generally, and there are exceptions, as Rosie mentioned earlier. Emergency Medicaid would be one of those. Also, coverage of children under the age of, up to age 21, and the Pregnant Women and New Mothers program, programs that are funded under Medicaid for those particular categories of folks would not be included. There is housing assistance, public housing, Section 8 housing vouchers and rental assistance. As Carlo mentioned earlier, there are a lot of housing programs that are not included in that list, but specific public housing and Section 8 housing vouchers and rental assistance are to be considered under the new public charge rule. And then the federal, state, and local and tribal cash assistance, those have always been, they were specifically listed out if they're for the purposes of income maintenance would be considered. Let's see here. I do want to note that specifically in the rule, there is language that speaks to disaster emergency relief cash. Cash for disaster emergency relief is not to be considered in the public charge assessment. And I mention this specifically because I know a lot of states and local governments are trying to create different emergency cash programs that are very short term, 1 month or 2 months, one-time only type of benefits that are state and locally funded, and they are, trying to track language that follows the federal Stafford emergency assistance, program, and the FEMA programs that are cash assistance. So I just want to flag that for you all, that a lot of the local and state programs that people are trying to create to address people's emergencies at this particular time to help them pay rent or to, stay in their housing, those kinds of things. A lot of those programs would not be negative in terms of the assessment for public charge. In addition, I just want to flag a bunch of things. The rule did take effect February 24th, and what we're seeing, like I said earlier, is much more of a chilling effect than what the rule actually is, what the actual impact of the rule is. And so, we want to make sure that folks get really individualized advice about, particular programs. And I highly commend to you the publications that the National Immigration Law Center and the Protecting Immigrant Families campaign have put out about these things, because quite frankly, we know that when people are trying to figure out whether to access certain programs, there's a lot of confusion about, specific benefits programs, how they're funded, et cetera. And so, it takes an understanding of how individual programs in your state, your services are funded, and understanding what people's immigration status are to, do an individualized assessment about whether people would be impacted. I also do want to flag that the public charge rule changes are not retroactive. So, benefits that were received prior to February 24th of this year would not be taken into consideration. But once the rule went into effect, it would expand, the assessment applying to benefits received after February 24th. The new public charge rule also evaluates a whole, range of different factors, a new set of factors to consider for people in determining whether somebody's likely to become public charge. The rule speaks to looking at people's education level, looks to looking at their work history, looks at people's general health to figure out whether or not they're likely to be able to work in the future. And so in balance, in looking at the whole range of circumstances, the Immigration Service is supposed to look at all of these different factors, what their income level, whether they've got a sponsor that makes enough money that might be able to cover, folks if they have an emergency medical issue in the future, et cetera. And so, all of these things are things they're supposed to consider. And so even if somebody has received public benefits in the past or is receiving benefits now, it wouldn't be automatically disqualifying. And so one needs to understand, that they have ways to overcome a negative consideration for having received public benefits by also, showing a long, steady work history or other factors. I do also want to flag just, as Rosie mentioned, specifically, the Immigration Service did put out some guidance around how they would look at any benefits that were received during this particular public health emergency. So people, would be able to explain, for example, if they lost their job, they weren't able to attend school, all of these different factors can be looked at in the context of COVID. And so USCIS will look at, the evidence about the totality of the circumstances. And many of us are doing, work to try to make sure that they look at that, the circumstances expansively, because we know even after this pandemic, it will probably take some time for the economy to recover and all of those things. So the other thing I do want to flag specifically about public charge as well is that I'm getting this question a lot from people. The receipt of unemployment insurance and unemployment benefits is not supposed to be considered in making a public charge determination. So that's one question I know I'm getting a lot of questions about. And also the tax rebate, that one is also not considered a public benefit. So those particular what's the term? Those particular cash assistance, or not assistance, but cash programs are not considered, wouldn't be considered under the public charge rules. So I'm going to move on because I know we're running short on time. So I'm going to move on to have Rosie talk about language access.
Okay, great. Thank you, Grace. And thanks to everyone. I know there's been a lot of information. It can be sort of dense to cover so much, but as Jenny wrote in the chat, people will receive the slides and a link to a lot of resources. We're also available for TA. And we've covered now most of the substantive part, and I'm just going to quickly go over some additional issues with regard to advocacy. But feel free also, if you have specific questions, to write those in the chat, and we'll make sure when we send out the webinar recording, we can also send out some additional information answering particular questions, or reach out to folks later. So as we've talked about around so many things, whether you're talking about immigration relief, about housing access, about benefits, about public charge, all of this requires being able to convey important information to immigrant survivors and hear from them as well. And so we just wanted to highlight again how critical meaningful language access is. So individuals who are considered limited English proficient, or LEP, are those who do not speak English as their primary language and have a limited ability to read, write, speak, or understand English. But we need to realize that many individuals with LEP, they're in the process of learning English, but at the same time, abusers at times get in the way of individuals even being able to learn English, or as we know, sometimes immigrant survivors are working around the clock, and all the barriers we ourselves encounter to learning a second language. So how do we, again, acknowledge their strengths, their resiliency, their courage in reaching out for services, and make sure that language is not a barrier to having meaningful access? We want to ask a poll question because of time. But the question was, if a survivor tries to go to a local DV shelter and the shelter doesn't have any Spanish-speaking staff or a plan for language access, is that a problem? Are organizations required to ensure that there is meaningful language access? And the answer is yes. That under Title VI of the Civil Rights Act of 1964, it says that organizations that receive federal funding cannot discriminate based on race, color, or national origin. And the Supreme Court in 1972 interpreted that to impede someone's ability to meaningfully access these services because of language is national origin discrimination. So all of our organizations that receive any federal funding have these obligations, and the obligation is to take reasonable steps to ensure that individuals with LEP have meaningful access to all of the benefits and services, not just those covered by federal funding. By virtue of receiving any federal funding or even the pass-through of any VAWA, VOCA, HUD, FIPSA money, even if it comes through your state, you're essentially saying, I agree in taking this money to make sure that everyone has access, including those with limited English proficiency. So as we know, it's the right thing to do. It improves the access to services and the outcomes, and it is a legal obligation. And the best way is to be proactive, not wait until one has a crisis situation, but really to ensure that we're striving for equity, that everyone is able to seek safety and well-being. And we do have resources to help you all develop language access plans and to really look at the demographics in your community, what are the most commonly encountered languages, but to also have a plan when less commonly encountered languages you find a survivor in need of services. So there are a lot of other resources, webinars, and tools, but we just wanted to highlight how critical that is when you're doing housing advocacy as well. I turn it over to Grace to just a few final notes on improving access to safety for immigrant survivors.
Yeah, I'm going to skip really quickly to, where is it? As we're talking about these issues, I just want to flag for your organizations how, some things to be aware of relating to safety. So in working with survivors, I mean, there's a lot of things to do to try to mitigate some of the system-related risk as it relates to immigration. And so supporting survivors in being able to help build their immigration cases, helping them safety plan about knowing their rights, what to do if they are stopped by immigration for some reason or detained, but also being very aware of your organizational obligations if immigration, for example, were to come to your program looking for individuals. And so just want to reiterate the important confidentiality protections that you may be subject to for the purposes of your funding. If you receive any VAWA or FIPSA funding, or your state law has confidentiality obligations, that if immigration were to come to your location, that you would have the same obligations as you would if CPS or local law enforcement or others coming to your program seeking somebody. And so those are, you should be following your confidentiality protocols if you're being subpoenaed, et cetera. The same ones apply to ICE as they do to anybody else looking for information from your organization. And also, I just want to flag another realm or statute specifically protecting certain locations, including shelters, rape crisis centers, supervised visitation centers, victim service providers, community-based programs. The Violence Against Women Act, 8 U.S. Code 1367 has particular guidance about immigration enforcement in certain locations. And ICE, Immigration and Customs Enforcement have to follow certain internal procedures before they're allowed to do enforcement in these particular locations. And so if enforcement against victims takes place in some of these locations, there are procedures and complaints that can be filed, and potentially if they are found to have violated these protections, individual officers and their supervisors can be subject to fines.
Thank you, Grace. So that brings us to the end. Thank you so much. This is just an example of proactive outreach. This was put together by the Minnesota Coalition for Battered Women, now called Violence Free Minnesota. And just recognizing that we shouldn't just be waiting for immigrant survivors to come to us. It's important to engage in the community, to let people know that your services are available to everyone, regardless of immigration status, and that everyone has a right to live a life free from violence and for their safety and well-being. So there are additional resources, and Jenny also put the link here, and I'll hand it back to you, Carlo.
Thank you so much. This is wonderful. We are at time, so I just want to give a big thank you again to Grace and Rosie for presenting today. A reminder that the slides and the recording will be sent out after this webinar, so don't fret. You can definitely listen to the recording. I know we had some audio issues today, so you can check back on the recording later. And again, I just want to give a final thank you to you all as advocates who are working so hard every day for survivors. You are so important to the cause and the movement, and we are just so appreciative of the work that you do for survivors. Please take good care and have a wonderful rest of your day. Thank you.
Thanks, everyone. Take care.
Thank you, everybody.